if we go back in time on those pinky purple IT34 forms that we're all so used to, but it's applicable to all assessments, but it's the key document of assessment that we are used to. We've always had a process date, we've always had a due date, and a second date. Historically, the process date was irrelevant, and everything in the world revolved around the due date. And going back in time, 30 days from the due date gave us the second date. Those were straight calendar days, and that was the date for payment without further interest being imposed. Historically also, that was the date by which we needed to lodge our objections. It was a clear date that we could see on the IT34 to make sure that we lodged on a timeous basis. Then, as things moved in time, the introduction of business days came into the issue. The due date was still the critical and pivotal date, and 30 calendar days from the due date was still the second date and the date for which payment had to be made without interest. But the date by which you needed to lodge the objection was now 30 business days from the due date, a day further in time than the second date, but not recorded on the assessment. And it didn't matter if we were still focused on doing everything by the second date, because we would still be timeous in lodging our objections, because in fact the business days gave us extra time to lodge. Then, as things developed, we had the request for reasons came into the equation, and once again that was 30 business days from the due date that triggered the request for reasons, and then the objection process was suspended. And we've also had additional time to lodge the objections that has been there for some time. But now, with the advent of the Tax Administration Act, the due date, it pales into insignificance. I always liken it to the pregnancy due date, a date to focus on, but meaningless in reality. All that the due date does is to set the point by which 30 calendar days must flow for the second date, which is still the date by which payment must be made without interest. But now the key, critical, pivotal date is the process date, and the objection process now flows from that process date and not the due date. Now, for many of us, our systems in our offices have not reacted from the 1 October 2012 change, and now we are all lodging our objections late because we're still focused on the phantom due date and not on the process date anymore. And there's no defined date on the IT34 that says this is the date by which you must lodge the objection. You've got it calculated for each and every matter, and that's where we all are making mistakes. But we need to make sure that we get our systems right, because if we are not lodging on time, SARS is being very forceful about rejecting late objections if you are outside the 30 business days from the process date, and if you are outside the additional 21 days given for reasonable grounds, and then you have to move to the up to 3 years, but you've got to show exceptional circumstances, and we'll look at that in more detail. But the key issue is the focus is now the process date, a lot earlier than the due date. Historically, the process date was then given time for the assessment to go to the SARS mail room. From the SARS mail room, the the post office, from the post office to your mail room, and from your mail room to your desk, and hopefully the assessment reached your desk on or before the due date to begin the process with clear days to deal with it. But now we have instant gratification with e-filing, and so SARS is saying, I don't need to give you an extension of time to lodge your objection. I'm moving my key date to the process date, because that's the date that you will get the assessment on your system, and that's the date that you must then react. And unfortunately, our systems have not all changed to this new system of the key dating. Now, yes, for those of you on the webinar, I'm going to take a question, and so there will be a bit of a pause in the sound, and I'll repeat the question afterwards, or the key parts of the question. Yes, sir?
I just want to know, when you look at the type of assessment, that's maybe also important, because if you look at an estimate assessment, which is Section 95 of the Tax Administration Act, and you look at Section 91, specifically where it says, well, if you did not submit the return, you cannot object on the estimate assessment until you submit the return. So you can't follow your objection rules until you follow that process, because it's an estimate assessment. And I just want clarity on that specifically.
Well, it's not a common exercise when they're going to just issue, sorry, the issue is the timing on the lodging of the objection when there's an estimated assessment versus an original assessment. It's not a common exercise for them to do an estimated assessment without having consulted with you, and you would generally be the one to bring that estimated assessment to bear because of your limited records. So if SARS has just done an estimated assessment out of the blue without that, then to some extent that falls in as an original assessment and not an estimated assessment. They're making that determination. The estimated assessments are generally an agreed assessment in the old language. So you would still be lodging the objection to that, because SARS has to show a reasonable basis of making that estimated determination. And if they haven't done that, that is what you're objecting to. So, yeah, there are some times where they are being gung-ho and raising generally to make a credit go away. But that's luckily not the norm, but you are objecting to the basis upon which they have raised that estimate without showing a reasonable determination. So when you lodge your returns, you will be lodging the returns with all the amounts that you deem to have been received by or accrued to the taxpayer. You will lodge the return with all the amounts that you believe are deductible in terms of the general deduction formula, and you will lodge your return with all the various capital allowances and other deductions that you believe the taxpayer is entitled to. So any variation from what you have lodged would be an amount that SARS has deemed to have been received by or accrued to. It wouldn't have been an amount that's actually received by or accrued to. It would be an amount that has been deemed to have been received by or accrued to by SARS. And to that, you're going to lodge objection in broad terms. If they have disallowed some deduction, it's an amount that SARS has deemed not to have been actually incurred, and you're going to lodge a general deduction, a general objection against that disallowance. And if it's an allowance that SARS is not now allowing, you are also going to lodge an objection to that, and all the penalties and all the understatements and all the interest that flow from it. And hopefully, if you start your objections with something like that, you've got a broad brush shotgun, a general antibiotic against all the various issues that SARS could have raised in that assessment. And so somebody wiser coming down the line at Rule 11 has something to put their coat on as to why you have already objected to that amount of income, or to that deduction, or to that allowance, or to that penalty that has been imposed. And then thereafter, you'll bring in with the detail of why you're objecting to the matter. So our office is using this as a standard opening foray in the objection process, and we're sharing that with others as to begin the debate on what needs to be done to make sure you're covering all the bases in the objection. Now, if you go back in time before the new Constitution, before the Tax Administration Act, there's an old case with Wirsky, one of the leaders of the time. And in that case, the key issue was an objection, capital versus revenue. And in the objection, they amplified the objection by saying it's capital due to the sterilization of the assets. And during argument, they attempted to go broader than sterilization of the asset, but still within great parameters of capital versus revenue. And SARS tried to limit the argument of the taxpayer solely to sterilization of assets and not to the broader issue of capital versus revenue. The court allowed the broader argument to take place, but it showed that even then there was a focus that the objection needed to be crisp, clear, cover all of the issues you want to cover in the court case, because you could be limited to it. That's how we were taught at university, but things seem to have moved from then, that people are now more slack in the drafting of this fundamental starting correspondence that is going to lead to the litigation process, and are being sort of lazy in their language, not covering all the key issues, as was the case in Computech, not looking at the underlying causes of all of the problems that could have resulted in the raising of that assessment, to make sure that they are raising all the key issues in the objection. Now, one can object to broader things. One can object to various decisions of the Commissioner. One can object to them not extending the time to lodge an objection, or to the rejection of an objection because it doesn't meet certain criteria, or the non-payment of a refund. There are broader issues that one can object to, other than the key issues that we are all familiar with on the IT-34s. Now, if we go back and just see where we are in this process now, we have an assessment. Firstly, one must check that assessment and see whether we are in dispute. Are you aggrieved at the assessment that has been issued? So SARS raises an assessment for 1 million rand less than they are meant to. You are not in dispute, you are not aggrieved, you make payment of that assessment. Now your affairs have changed dramatically, so once you lodge the return, your return has been assessed as you submitted it, but now your business is in financial difficulty and you can't pay. There is a provision in the Tax Administration Act to make an application for deferred payments, to make an application for a compromise or a write-off. One can't just be an ostrich. One must deal with the issue of one's inability to pay, even if one is not in dispute with the assessment that has been raised. SARS raises an assessment at 1 million rand more than your taxable income disclosed. You're going to need to lodge an objection process. That would be the request for reasons, the objection, and maybe ultimately an appeal, and the process that follows from that. But parallel to that process, you're going to need to be mindful of the request for suspension of payment to ensure that recovery action ceases. It's not automatic upon the lodging of the objection, but there now is a hard-fought process that allows one to make such an application. So now you have an assessment that is, yes sir, at the back. I'll cover that in detail. I'll cover the suspension of payment in detail. So you've now got an assessment that has been raised. One of the first issues that you must look at when assessment is raised is the issue of prescription. Are they outside of the 3 or the 5 year time frame for them to have raised that assessment in any event? And if they are outside of the time frame, have they considered this at all? Have they considered their responsibility and their onus to show that there's been fraud, misrepresentation, or non-disclosure? And if it is before the assessment is actually raised and you're still in the audit process and now prescription has come through, you need to make sure that you're raising that to protect your rights of the taxpayer. We have some matters going on where SARS is trying to look at 5 years. We are fighting to limit them to only look at the last 2 years because there's prescription. And we're saying they can't come on a fishing exercise where there is prescription. They must show that there has been fraud or non-disclosure or material misrepresentation before we're going to let them into the door to even begin an audit on those years. So we need to make sure that we're covering these things. Yes, sir, at the back.
Does the prescription happen from the process date or the due date?
Well, this is one of the areas which has still got to get settled with the older matters. So the older prescription historically was based on the due date. Now the dating of the assessment is the process date. So my view would be, in terms of the Tax Administration Act, we're now using prescription as defined then because we're dealing with the matter now. Therefore, it would be the process date and not the due date that would trigger the prescription. But I think that's still going to get settled at some point in time. Is it very hot for everybody, or are you happy with it?
Yes.
You're happy? Okay, that's fine. All right, now there are issues on onus of proof. We've got the onus of proof on many, many matters. But SARS has the onus of proof on some matters, and we need to make sure that they are focusing on where they have that onus. So if they do an estimated assessment, they have the onus to show that that is reasonably calculated. And if they are using an understatement penalty, they have the onus to show the facts that they have imposed. There are still many times that they are saying, we are going to impose an understatement penalty in terms of the Tax Administration Act. That is not correct procedure. They have the onus to show the how and the why, and then you have the ability to object. And if they've done such sloppy wording in the letter of findings, you need to put them to task in your response to the letter of findings, indicating where they have an onus. There are issues on the reconciliation of VAT to turnover, and they need to make sure that they've used a proper basis for such an estimate in order to raise an assessment, and there are various challenges that can be levied in that regard. They have an onus. We must forget that they have an onus on key issues. We've got an onus on many, many issues, and they are quick to remind us of our onus. We must remind them of theirs. Now you lodge your objection, and SARS has the right to throw that objection out because they do not believe that it meets the criteria. For the majority of the objections, we are going to be using the requisite form, which will then prompt us to have taxpayer name, number, date, and the amounts, and all of those key issues. The one issue that still is problematic is the issue of signing of that objection. Most of us have powers of attorney, but I think that professionally we need to make sure that the taxpayer is aware of that objection and has consented to us lodging that objection. What we do in our office, I see there's some frowns, what we do in our office, we send them our letter, we send them the printed NOO form or the ADR1 form which they sign, and we generally are attaching that, although we hold power of attorney, we're attaching that as the scanned documentation to show that the taxpayer is aware. I believe that if we are just lodging objections without bringing them to the knowledge of the taxpayer and having their consent in the process, we could still have some professional implications later. It wouldn't deal with the invalidity of the objection because we have the power of attorney, but I think professionally we need to make sure that we are taking instructions and that those instructions are given to us by the taxpayer and that we don't just do our own folly. But that does fall outside the scope of this, but that would be my view on the matter. Now,